You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Well, thanks very much for once again tuning into the Max Planck Lawcast. It's great to have you here with us. Now, today's podcast is a little different to our usual fare in that it forms the first of a two-part series on the fascinating subject of artificial intelligence and crime. Both episodes were recorded in March 2023 at a conference held at the University of Buenos Aires. There's actually a link in the description with more information about the conference itself, including the participants involved and the topics covered. The conference was co-organized by the Otto Hahn Research Group on Alternative and Informal Systems of Crime Control and Criminal Justice, which is based at the Max Planck Institute for the Study of Crime, Security and Law in Freiburg. This first episode takes the form of a roundtable discussion about predictive policing and predictive justice. It is hosted by Linus Ensel from the Max Planck Institute. He is joined on the microphone by Emmanouil Billis, Otto Hahn Research Group Leader, Julian Roberts, Emeritus Professor of Criminology at the University of Oxford, and Elizabeth Tiarks, Assistant Professor at Northumbria University. So sit back, relax, and enjoy.
Welcome. My name is Linus Ensel. I am a doctoral researcher at the Max Planck Institute for the Study of Crime, Security and Law in Freiburg in Germany. My colleague Christian Tönnes and I are hosting a special episode today on artificial intelligence in crime control and criminal justice. And we are actually recording this podcast at the Faculty of Law of the University of Buenos Aires. And the reason that we're recording in Argentina is that we're here on the occasion of the Max Planck workshop on AI and the rule of law, which took place on March 30th, 2023 at the University of Buenos Aires within the framework of the International Colloquium on AI and the Administration of Justice, which was organized by the International Association of Penal Law. The structure of the podcast will be the following. In the first part, my guests and I will go into the topic of predictive justice. And in the second part, my colleague Christian will talk with his guests about predictive policing. Giving the word now to our first discussant to briefly introduce us to the basic meanings, problems, and ideas behind the main concepts of today's discussion: AI, predictive justice, and predictive policing. Our first guest is Dr. Emmanouil Billis. He's a research group leader of the Otto Hahn Group on Alternative and Informal Systems of Crime Control and Criminal Justice at the MPI for the Study of Crime, Security and Law in Freiburg. In addition, he also organized the aforementioned Max Planck workshop on AI and the rule of law here in Buenos Aires. Emmanouil, thanks for being here. In your presentation today during the Max Planck workshop, you spoke about the opportunities and the challenges that these new AI technologies are posing for crime control and criminal justice, but also for the rule of law. Would you like to summarize for our audience what these opportunities and challenges currently are?
Okay, yes. Thank you very much, first of all, for having me here. First, many thanks to both of you and to our friends at the Max Planck Law for organizing and hosting this special podcast episode. This provides my research group a great opportunity to present from the beautiful law faculty of the University of Buenos Aires insights into our studies and some of the findings we have been discussing in the last few days during a really very interesting international colloquium, which was organized by the International Association of Penal Law here in Argentina by the IDP. Thank you also for including our esteemed guests and members of the Buenos Aires Max Planck team in the discussions of this podcast on predictive justice and predictive policing, as these predictive justice and predictive policing are really two very important notions which are currently shaped by recent technological advancements in the AI field. Now, to come to your question, finally, I think that we must first of all be aware of the fact that in the context of prevention and detection and suppression of security and criminal threats, as well as in the context of the delivery of criminal justice, the relationship between law and new technologies is a complex one, a tense one, a multi-layered relationship. So, due to the continuous technological progress, we have already witnessed the development of AI mechanisms which are capable of making the exercise of public authority in the law enforcement field more effective and more efficient. And we have also seen that legal decisions in the criminal justice field can be more objective and less arbitrary by the use of AI. For example, AI systems based on predictive algorithms and analytical software can be used nowadays to prevent or detect crimes. And AI systems can be also used to assist prosecutors and judges in their decision making, for example, with respect to assessing evidence or assessing the risk of recidivism or with respect to reaching good, proper sentencing decisions.
Thank you, Emmanouil, for laying out those opportunities of applying AI tools in crime control and criminal justice. But what are, in your opinion, the challenges posed to legal systems by the use of this new technology?
Oh, yeah, okay, yes, of course, the challenges that many are great. Indeed, the use of AI has the potential to radically expand the state's powers of surveillance, of intrusion, of coercion, and this entails various rule of law and human rights concerns. We have some very important unresolved issues that policy debates and interdisciplinary research must urgently address. This includes, most importantly, the problems of how to develop fully explainable and transparent AI and machine learning systems, how to achieve objective and non-discriminating automated decisions and outputs, how to build functioning models of accountability and responsibility with respect to AI-based actions and decisions. And of course, as always, we also have, if you like, on a more philosophical or ethical or symbolic level, we have been, I think, already experiencing, and we have seen that already during the recent global COVID crisis, several dystopic scenarios we as organized societies must deal with.
Could you perhaps point out some recent examples for those developments that you're describing?
Oh, yes, of course. Take, for example, the most obvious example are the social credit systems, which are AI-based in many aspects. These are the social credit systems that are already put in place in some countries, or the very advanced predictive mechanisms, which are already in development, that remind us a little bit of this infamous movie, the Minority Report movie, or simply the general program of how to accept robots which are mimicking human law enforcers in an otherwise human-centric world. A human is in the center of all actions. We just right now witnessed last year and the year before during the COVID crisis, dog-shaped robots stopping individuals, shouting individuals. Perhaps in the near future, dog-shaped robots will be questioning us, and we must see how we feel about this and what we want to do with this.
So it's clear from what you're saying that the new AI technologies are having an increasing impact on law enforcement and the administration of justice. Could you perhaps also give us a brief description for the podcast's two main concepts, predictive policing and predictive justice?
Oh, yes, gladly. Of course, actually, we have no binding general legal definitions of predictive and policing and predictive justice yet. But there are many proposed definitions in literature and also in soft law instruments. So very briefly, predictive policing basically refers to the use of mathematical formulas and of complex analytical techniques in law enforcement with a purpose to identify potential criminal activity and to prevent crime. And this can be achieved nowadays thanks to modern AI tools and algorithmic systems through the swift collection and through the automated or semi-automated processing of vast amounts of data, personal data, business data, statistical data, for example, historic crime data, or even location-based data. And in this sense, I think that the main methods that predictive policing can include are advanced electronic methods for predicting crimes, for predicting offenders, for predicting perpetrators' identities, and also methods for predicting the victims of a crime.
And what about predictive justice?
Okay. Predictive justice is also a complicated concept. The best way to summarize it is I'm going to quote from the first draft of our preliminary resolutions here in the Buenos Aires colloquium. According to our resolutions here, the term predictive justice refers first of all to anticipating someone's behavior by using AI, for example, to assess the flight risk during the pretrial procedure or to assess the risk that an individual will commit or recommit a crime, and we use this AI in order to help us take a decision concerning some issues, such as, for example, a decision about the necessity of pretrial, or even a decision on sentencing or on parole or on probation. And secondly, AI, predictive justice, also refers to predicting the content of judicial decisions by using this technology to perform very quick statistical analysis of prior decisions which were issued in similar cases in order to see what a future judge will decide on the same topic. Now, aside from these definitions, it is extremely important to note that both predictive policing and predictive justice directly connect to sensitive socio-legal and legal ethical questions about justice, about legitimacy, about democracy. We have here, for example, the very important issues of privacy and data protection, of transparency and bias, deception, explicability, accountability. So what does this mean for our research? What does this mean for legal policy? It means that we need to find the best ways to address the relevant challenges regarding these fundamental values in a practical manner. And in this context, I believe that one of our first priorities must be to design and to use the AI systems in accordance with one overriding objective. This objective is to protect and to secure respect for the most basic human and social values.
Thank you, Emmanouil, for your clear position on this and for this overview of the main concepts explored in this podcast. Now we would like to get a bit more specific, digging into the topic of predictive justice and particularly of AI in criminal sentencing. For this part, we have with us Professor Julian Roberts from the University of Oxford and Dr. Elizabeth Tiarks from Northumbria University in the UK. Thank you both for being here. Julian, could AI eventually replace the human judge in sentencing? You touched upon this in your presentation earlier. Maybe you could elaborate a bit on this question.
Yeah, AI has clearly revolutionized medicine and many other areas of public policy, and it's had a huge impact already in law. Whether it can replace the judge at sentencing is another matter. I'm confident that AI will develop and evolve to a degree where machine-determined sentences will become available, and these will mimic and be a potential substitute for the human judge. However, there are aspects of sentencing which cannot be captured in a machine learning environment, principally the sentencing hearing. And so I think there are clear limits on the intrusion of AI into the sentencing process.
So if AI can't replace human judges, how could it maybe assist them?
Well, it can assist them in a number of ways, and possibly depending upon the jurisdiction. In England and Wales, we operate sentencing guidelines, and these are basically packages of information for the court, which contain sentence ranges, starting points, and aggravating and mitigating factors. And the guidelines are designed to promote consistency at sentencing, which of course is a key rule of law requirement. And AI, machine learning, can assist in a number of ways in this context. First of all, it can help devise and develop a better guideline. So the guideline is supposed to give information on the most significant sentencing factors, for example. And AI, machine learning, could digest effectively the accumulated judgments over a huge period of time and produce a much more accurate idea of the most important sentencing factors that have been invoked in the past by courts, and particularly by appellate courts. So improving the guidance that's available to a sentencing court is one area in which AI can help. AI can also serve a very useful analytic or research function. So right now, we identify problems in sentencing through pretty crude human-based research. We take sentencing patterns and we try and see, for example, whether women receive harsher or more lenient sentences, whether the use of imprisonment is higher for visible minorities compared to white defendants. And we've learned a fair bit about human decision-making, human sentencing from that research, but machine learning can do that job much better.
Let me head over to you, Elizabeth. In your presentation, you touched upon the purposes of sentencing. How could they interact with the introduction of artificial intelligence in the sentencing process?
Yeah, so in my presentation, I talked about the fact that we have different purposes that sometimes pull in different directions. And in the case of England and Wales, there are 5 statutory purposes, which the judge selects between when they sentence, and they can't necessarily have a sentence that meets all 5 purposes at once. So at the moment, a choice has to be made between those different purposes. And I think it's actually quite unclear how a machine learning algorithm or a similar AI tool would be able to assist, because essentially it's a value judgment at this stage. I suppose what it might do is make us reflect really carefully on what we're trying to do with sentencing and why, if we're going to try and create a tool that optimizes for a particular purpose, for a particular reason. At the moment in England and Wales, we have risk assessments feeding into this. So algorithmic-based risk assessments. It's unclear, I would say, how these factor in relation to the purposes of sentencing, but probably the one that is most relevant is the protection of the public. If we're thinking about risk to the public, risk of harm, risk of reoffending, that's slightly problematic, I suppose, because these purposes are not supposed to have a hierarchy. So if, and we don't know if it is, but if that is meaning that judges lean more towards one particular purpose where they have a risk assessment before them, then we need to sort of reflect whether we're happy with that situation. But also we might want to go back and get more clarity on exactly what we want that tool to feed into and why as well.
When we speak about implementing AI into the judicial decision-making process, we often think about transparency issues. Why is transparency in sentencing important, and how does AI relate to that?
So transparency in sentencing is really crucial in terms of it being able to be understood why a particular sentence has been arrived at. It's important to supporting public confidence and trust in sentencing, as well as penal legitimacy as well, in supporting that. And if we think this is something of an obvious point, but sentencing is a really intrusive power that's exercised by the state. So the legitimacy of that use of that power is extremely important, can have an impact obviously on the offender, but also a wider impact on the victim, the public, and perhaps also dependents of the offender as well.
So if transparency is so crucial for sentencing, should we even consider the use of AI in sentencing today?
I think it's problematic at the moment. If we look at the example that I used in my talk of what we currently have in place in England and Wales, which is not perhaps something that could be termed AI as such, but is use of algorithms, risk predictions in sentencing. I think the problem lies in both understanding the way that the algorithm has arrived at the output, which is obviously more problematic where you have a proprietary algorithm, such as Compass used in the US, but is also a problem for what we currently use in England and Wales in terms of OASIS, because there is some information released about it, but it's not hugely expansive. There's no legal framework supporting how much information needs to be released, how often it needs to be released, how up-to-date it needs to be. And there's also an issue with whether that information is usable. We have defendants who are unrepresented in court who may not even know that this information is available or even understand what the assessment system is or what the risk assessment means. Where people are represented, we have time issues. The court is pressed for time, lawyers are pressed for time. And it may be that they simply don't have either the technical expertise or the time to go into detail in terms of really understanding what the information available actually means in terms of how the algorithm arrives at the output and the extent to which they're able to challenge that. In addition to that, in terms of a lack of transparency, there's the way that the probation officers who input the data into this system exercise their discretion. We don't really know exactly how discretion has been exercised, whether it's been exercised in a positive way or in a way that we would be concerned about. There are just a number of levels where at the moment there isn't enough transparency to get a full understanding of exactly what's gone on and really trace the decision-making process in terms of the use of algorithms.
Julian, to avoid some of those transparency issues that especially arise when using a data-driven machine learning approach, huge data sets, black box, we don't really know how the AI gets to its results, wouldn't it be preferable to have a non-learning sentencing algorithm in which we would just implement the statutory sentencing criteria so we would get a rule-based system that we can fully control and fully understand?
Yeah, it could be. I mean, the way it would work, I assume, is you would input into the machine program the statutory objectives of sentencing, purposes of sentencing. You'd input the principles of sentencing, such as proportionality, restraint, equity. And then you would direct the machine learning algorithm to apply those principles and objectives and to generate a sentence. But I think in a sense, so that would have greater transparency. It would be rule-based and based on the statutory framework of sentencing. So it would conform to a lot of the requirements that we might expect of a sentencing decision. But what it wouldn't do, it would fail to capitalize on the vast power of the machine to learn for itself and to devise its own sentencing patterns based upon its analysis of previous judgments and applying them to the case before the court. So I'm not sure, but I think however the AI program is constructed to assist courts or replace courts, you would have to input into it and factor into it the sentencing objectives, principles and purposes, and then it would apply those.
Can I just jump in there to give an example? So the offender reconviction scale, which I mentioned in my talk, only uses static risk factors. So it is, as you say, a non-learning algorithm. So in theory, we could have enough information about how it arrived at the decision. It's quite simple factors that are input, factors that are going to change much over time. But the issue then, in terms of transparency, is still that you have a human, in this case a probation officer, who is interacting with the tool when inputting that data. And we probably do still want them to be able to exercise some discretion in terms of the resulting risk prediction. And the example I gave in my talk was from research carried out by Maria Ansbro back in 2010. She looked at a number of cases where probation officers had exercised discretion in relation to inputting into the offender reconviction scale. Sometimes the discretion was exercised in ways that seemed unfair. But there was one example that she gave of a case where it was exercised and seemed necessary that it should have been exercised in that way. And that was where the probation officer was dealing with sex workers who had a number of prostitution-related previous convictions, which had been classified as sexual offences, and they therefore had a really high risk score that the probation officer, using their clinical judgment, their professional judgment, could see wasn't commensurate with their actual risk. So they were able to manually adjust for that. So I think in terms of transparency, if we're going to allow, and we probably do want to allow, some discretion to remain in terms of how the human interacts with the algorithm, we're going to retain that problem of transparency unless we have something in place. I don't have a suggestion, but something in place where we can trace these decisions a bit more carefully in terms of when discretion has been exercised, how it's been exercised, and in what way.
Thank you. I would like to get back to something you just said, Julian. You spoke about the possibility of implementing sentencing principles into a sentencing algorithm. How could we translate or transfer such human-made concepts into an algorithm in a way that the machine could work with it? Would that be feasible?
Well, I'm not a programmer, but I would have thought, let's take a principle like proportionality. So we would direct the machine learning to devise a proportionate sentence in a particular case. The machine would have access to all the information relevant that could be entered into the computer, all the relevant information, seriousness of the crime, the impact on the victim, factors relating to the offender, drug addiction, all this sort of stuff. And then the computer would attempt to devise a sentence which was proportionate to the harm and culpability as evidenced by all this information which had been put in. Now, that's an individual determination or calibration of proportionality. So this gets to the question of whether it should be individual or comparative, which is an interesting question which came out of your presentation. And the computer in this case would effectively have an idea of how much harm was inflicted and how culpable the offender was, and the sentence that would be imposed would be one which would be based on that determination in comparison to previous cases. So let's take a crude example. Let's suppose that the case of robbery, and having digested all relevant information about the robbery, the crime, and the offender, the computer came up with a score of 7 for harm and 6 for culpability. It would then match those scores to a sentence, the severity of which would reflect similar cases which had attracted scores of 7 and 6. And so at the end of the day, that sentence would be proportionate to the harm and culpability based upon the computer's more sophisticated consideration of all the relevant factors. And so the computer in this case, the machine, wouldn't be susceptible to errors such as, for example, ascribing a very low culpability score because the defendant happened to be a nice young person who reminded the judge of him or herself, and so on. So the computer might give you a cleaner, a better calibrated determination of the harm and culpability, and would then match a punishment to that level of harm and level of culpability.
Yeah, so just to chime in relation to proportionality, and I fully accept what Julian's saying in terms of the potential here for the machine to do better in terms of reducing bias that might exist in judicial decision making. I think my concern would be how you go about building this tool, because in terms of assessments of harm and culpability and taking into account different factors, obviously we have really structured sentencing guidelines in England and Wales that help enormously with this. But there is always that element of discretion and the making of value judgments at play that is, in my view, almost impossible to eradicate altogether. So it's how you would go about building that tool and being able to make these assessments of harm and culpability. And then, of course, how you bring those together into one assessment of seriousness to then match to a proportional sentence that I think remains a problem. I suppose I can't immediately see how you would resolve that. And it goes back to, I think it was HLA Hart who raised this issue of assessing harm and culpability and how you bring those two together, and that it's just, there are so many value judgments, so difficult to isolate in one right answer in relation to any particular case that you're assessing in this way.
We learned a lot about AI in sentencing today, and I think this is a topic that will stay with us for quite some time still. Julian, regarding the future, are you skeptic of what's to come, or is your outlook rather optimistic?
Yeah, I think it will improve sentencing, as I've mentioned in my talk, by improving our understanding of how humans make decisions at the sentencing phase of the criminal process. So I would anticipate two particular developments that I would approve of. First of all, I can see that we may come to a point, and rapidly, that we have a machine-derived sentence for less serious crimes, minor crimes, crimes that involve possibly only a monetary fine. The machine would devise and output a sentence, and then we'd hear from the parties. So I'm thinking of the adversarial model, where if the parties are in agreement, the sentence imposed is generally what they've agreed. In the common law jurisdictions, judges don't overturn a sentence that's been jointly proposed by the parties, because that's the tradition. So supposing the machine generated a sentence of 1,500 euros, that's the fine. And if the parties are in agreement, that prosecutor's representing the state is content with that, the defendant is content, why would you need thereafter to have some human intervention? If one of the parties was dissatisfied, then you might proceed to a human sentencing hearing where a human judge would determine the level of sentence. So I think that's quite likely to proceed, and that doesn't strike me as being a scary prospect. The second thing that I think will happen, again in a short space of time, is we'll have a much better understanding of human decision-making at sentencing by the application of AI, applying artificial intelligence tools to look at human sentencing decisions, judgments, sentencing patterns, in order to permit us to detect anomalous courts, anomalous judges, factors which disadvantage minority defendants, sentencing options which are applied to the wrong profile of defendant, sentencing options which disadvantage women versus men, and so on. And I think we'll learn a great deal more about sentencing than we currently know. And I think that's also a very salutary development.
Yes, I actually agree with Julian in terms of the last point that he made, that we're in dire need of some way of getting more information about how judicial decisions are made. So if there's a way of building a tool or implementing AI in some way that we can get more information about why judges make the decisions they do, more information about potential bias in decision making or any issues, or even just as Julian said, just identifying factors that are used in specific ways that crop up time and again, so we can get a better idea of norms in sentencing, I suppose, then I can certainly see a role for it there.
Elizabeth, Julian, thank you so much for your participation and your time. I'm really glad we could make it happen here in Buenos Aires. I really enjoyed it.
Pleasure.
Thank you.
Thank you.
Well, I certainly hope that you enjoyed today's podcast. At this point in time, I'd like to do a very big shout out to Linus Ensel. Linus not only recorded the podcast in Buenos Aires, but also did all the editing and mixing, put it all together. And as anyone knows, it's actually those services that require the most amount of time. So Linus, thank you very much. You certainly made my life easier today. To our listeners, be sure to tune in to the second episode in the series, which delves further into the use of artificial intelligence in predictive policing. Until then, I'm Chris Murphy, signing off from the Lawcast. Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.